asset protection planning firm BarthCalderon. Thanks for checking into the Culture of Asset Protection TV channel here on YouTube. If you haven't subscribed yet, click below. There's a link because we put out some really great videos on planning issues, and my colleague Brad Barth is doing this video, and he is a top speaker on estate and asset protection planning to a ton of groups across the country. This is a really important topic. I hope you enjoy it. Thanks for checking in, and I'll see you next time.
The biggest concern that most of us have when it comes to drafting an estate plan and kind of planning for the benefit of our family when we're no longer here is who's going to manage the finances for the benefit of our kids, benefit of our spouse, benefit of our beneficiaries. And so here, in my opinion, probably one of the most important decision that needs to be made is who is going to be the successor trustee. Now, when it comes to trusts, there's a couple of parties that they need to be aware of. One, you have what's called the grantor, the settlor, the trust maker, somebody who actually makes the trust, puts the box together, puts in all the provisions, identifies the beneficiaries and how someone's going to get those assets. The next person is who's going to manage those assets when the assets are inside the trust. That person's called the trustee. Now, ordinarily in a typical estate plan, let's say, for example, a husband and wife, the husband and wife, not only are they the trust creators, but they're also the trustees. They are the initial trustees. They continue to own and manage those assets for their benefit during their lifetime. So the next question is beneficiaries. The third component of the trust is who the beneficiaries are. And again, during most people, during their lifetimes in a standard estate planning type of trust, the beneficiary is also the people that make the trust, the individuals. That's why we call these revocable living trusts. The individuals who make them are called the settlers. Those same people are the trustees, the owners and managers, and those same people during their lifetime are also the lifetime beneficiaries. So it's because of all these control issues that the trust continues to act as you for tax purposes. There is no real change of ownership. You're just kind of changing how you're holding title. Rather than an individual, you're holding the assets as trustee. But one of the main purposes of creating a trust is to be able to have that orderly distribution of assets for the benefit of the beneficiaries. Now, I'm going to be addressing methods, benefits, advantages and disadvantages of how we transition those assets for the benefit of the beneficiaries in later video blogs. But for the point of this one is who's going to be what we call the successor trustee? Who's going to be the one who has legal ownership and management and control during the trust's administration for the benefit of our designated beneficiaries? For typically it would be our kids. So this person or this entity is called a successor trustee. Now here again, as I mentioned previously, in my opinion, probably the most important decision that you need to make is who this individual or individuals are going to be. Because they're going to be the ones who manage the assets for the benefit of the beneficiaries. And things that we need to take a look at is, one, I think a very important thing is what experience does an individual have as a trustee. When it comes to the world of what's called fiduciary duties, there is no higher fiduciary duty in the land than that of a trustee. You're pretty much managing the assets for the benefit of somebody else. And the court has high scrutiny as to how you behaved and manage those assets and report it to the beneficiaries, because after all, it's not your money. As a trustee, you're managing these funds for the benefit of a beneficiary and not for yourself. So what experience does an individual have? Do they have full knowledge and appreciation of what they're doing? Again, this could wind them up in some potentially serious liabilities as well because of that high fiduciary standard that the trustee is held up to. So one, you have experience issues. The second thing is you have commitment problems. I would say commitment problem, but commitment issues. One, how committed is the trustee to managing that trust for the benefit of those beneficiaries? Commitment means the investment powers, how are that continuing relationship, those reportings, those semi-annual, quarterly, or annual meetings, how committed are they to managing the trust funds for the benefit of the beneficiaries? Is it something that they're kind of doing while they're paying their own personal bills. Oh, I got to make sure I make a notation here in the trust. It's important that they have commitment, because again, you're managing someone's remaining legacy for the benefit of those beneficiaries, and it's not something that you do on a part-time basis. You want to make sure that your chosen successor trustee is committed to doing the job. It's a very, very important job. One of the next things we deal with is longevity. Many times we're creating trust for our kids. Our kids may be young. They may be, well, certainly younger than us. They may be early 20s, early 30s. Maybe they're only 5 or 6 years old. So if you're keeping assets in trust for a long time period, you're holding assets in trust for the kids until they're 25 years old, maybe 35 years old, maybe till they're 65 years old. Maybe it's being held in trust for them for their remaining lifetime. You need to make sure that we designate trustees who are going to be there to be able to administer those assets for the benefit of those beneficiaries while it's held in trust for those 20 or 30 years. So simply pointing your parents, who themselves may already be retired, they may not be around, for the next 40 or 50 years while those funds are being managed for your kids. You're talking a couple generations down. So you want to make sure that if you do want to list your parents, or you do want to list somebody who's a little bit older, that we have a series of successors listed in there. So if one person is otherwise unable, someone can step up, take that baton, and continue to manage those trust assets for the benefit of our younger beneficiaries. And I think one of the other very important things to discuss is about objectivity. So when it comes to managing money for anybody, one of the benefits about being a trustee is that we don't have a horse in the race. We have a job to do. And if I have to treat the kids equally, treat the beneficiaries equally, I don't have a particular preference of one beneficiary over the other. Where you have a family member, you have Uncle Bob, you have Aunt Mary, they maybe have a particular preference for one child over the other. And those kind of biases and preferences can kind of come through on how the money is being administered, how the money is being handed out or doled out. One child is getting disadvantaged by the other. And so objectivity is a very important part of having a trustee. So not only a family member who's able to maintain that objective standard, but maybe even having professional trustees having that objective standard as well. Here again, a job needs to be done. We have to manage trust assets for the benefit of the beneficiary. And again, we don't have a horse in the race. We need to make sure we treat all the beneficiaries equal because we're held to that standard of objectivity. And I think more than important than anything else, we also have the trust document itself. The trust document itself is our guidebook. It is our instruction manual on what to do. So when we have instructions, we have letter of wishes, we have instructions from the original trust makers on how they want us to deal with those trust assets, and the trust should spell out appropriately and clearly how those assets are to be managed, how those assets are to be distributed. Do you have a particular preference regarding the types of investments? Or do you want involved in real estate? Do you want those a broad standard? Do you want a standard diversified portfolio? Or are we to follow the Prudent Investor Income and Principal Act? All these are very important things that the trust document needs to spell out so that we're giving direction to the trustee. Because after all, that's ultimately what we're trying to do. We're trying to give the trustee a playbook. This is how I want my estate managed and administered for the benefit of my kids. These are my kids, and this is how I want my kids treated. This is how I want those assets distributed. So these are all very important rules when it comes to their selection of a trustee. And as I mentioned to it earlier, and I just started off, in my personal opinion, I think the designation of a trustee is one of the most important decisions that any individual needs to consider when making a trust. I think the other one I already addressed in a previous video blog is the designation of the guardians for minor kids. But here, when it comes to dealing with the finances, who you choose as trustee is again one of the most important decisions that needs to be made. It's not an easy job. There's a high liability associated with it, and you want to make sure that the individual that's chosen is responsible. They know the jobs, they have the experience, they have the commitment, they have that longevity, they have that objectivity, and they will follow the rules to make sure that your ultimate wishes are respected, and ultimately they're held accountable. So if the kids themselves, the beneficiaries themselves, feel that the trustee is not doing a good job, they need to make sure that there's some accountability there. And so here again, if you have an inappropriately chosen trustee, if those funds are otherwise wasted, there may not be much accountability because if all the funds are wasted, there's no way to go back after them. So if you have someone that's either insured or that does this on a regular basis, if there is a mistake inadvertently, then there is some type of policies that are available to go to recapture for a case of any misappropriation or any mishandling of the trust assets. So these are all very important elements to be addressed. I'll be discussing trusteeship on multiple video blogs in the coming months. It's just one of those areas that I guess, because it's such an important area in an estate plan, that this one 4 or 5 minute video, actually 10-minute video, just isn't going to do justice the scope and breadth of what's involved in trusteeship. So for right now, this is, I think, an appropriate introduction. I think something that people need to understand, acknowledge, and respect the gravity of the decision that's being made when they choose a trustee, whether they choose one individual, whether they put 2 people together, whether they put 3 people together with a majority, whether they use a professional trustee, whether they use a corporate trustee like a bank. These are all decisions that we're going to flesh out over the coming months. But again, the choice of who you choose as a trustee is very, very important and needs to be discussed. So if you have any discussions, you have someone who's a trustee, you don't quite know what the jobs are, someone's doing a good job, not doing such a great job, please reach out so we can talk about these issues. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all your tomorrows. Thank you for your attention. Bye-bye.